Now turn to the second case on this morning's docket. That is case number 104658, State of Kansas v. Robert Weber.
May it please the Court, Rachel Pickering of the Appellate Defender Office on behalf of Robert Weber. Chief Justice Nuss, if you could reserve 2 minutes rebuttal time.
2 minutes is granted.
There are several issues raised in Mr. Weber's brief. I'm going to like to address the first two this morning. I'm going to be quite greedy and try to get through both within this short amount of time. The first issue I want to deal with is the first issue, which is regarding multiplicity. This is what Mr. Weber was convicted of attempted rape and rape, and we would argue that those are multiplicitous. His constitutional right not to be held in double jeopardy has been violated. Now, what happened is Mr. Weber went over MW's house to fix some shelving. He comes upon her in the bathroom hallway and sees her undressing, says, now that I've seen this, I have to do this, and struggles with her and attempts to penetrate her with his penis. He's unable to, and then he does digital penetration. From that, the state has charged Mr. Weber with both attempted rape as well as rape. I believe, after going through the facts of this case, this is a classic example of multiplicity. What we have is a Schoonover, which provides us with the basis for how we should go through this. And Schoonover is really got gold stars next to it for me because it really explains how you discuss a case where you have two crimes being charged when you really just have one offense. So Schoonover gives us a two-part question. Do the convictions arise from the same conduct? And if so, by statutory definition, do these two offenses or are they only one? Now, of the same conduct, that question is done by a 4-factor test. We believe, and I would say the state almost concedes, this is happening at the same time and in the same location.
Let me stop you there because I was reading the briefs and looking at the memo on this case. There seemed to be a lack of clarity in the facts, and so in looking at the trial transcript, there's this notion that there's this struggle. There's an attempted penetration with the penis and then the digital, and then we turn back and have the attempted penis penetration, and in between we have a dialogue, or at least a question and answer about how long has it been since you've had sex, and that led me to believe whether we couldn't have enough time for a separate impulse. And when you look at the questioning comes up from the defense counsel about how long did this take, and the victim talks about the whole morning when they got there to when the police arrived, but it appears to also say that the attack, what I would consider the attack part of this, may have taken as long as 30 minutes. And if that's the case, and if we have to look at the evidence, I mean, given our standard of review, isn't it possible that there is evidence sufficient to say that there could be a separate impulse in between the time that they're talking about how long has it been since we had sex and the next attempt for penal penetration?
The record is unclear. My answer to you is we don't know if that conversation with Mr. Weber and MW took place while he was attempting to penetrate her with his penis. That's never clear in the record. And so we can't assume we can't assume because he could have been struggling. If this really was a half an hour, maybe the penile penetration was taking so long, and during that course of that, he asked her, "How long has this been since you've had sex?" Not since I've slept with my husband, which was 15 years ago. So I would argue that the state did not sufficiently present facts for us to show that there was a break. This could have been happening while the attempt was occurring.
But we know that there was a continuation of the initial impulse, at least, because after the digital manipulation or whatever occurred, there was a resumed attempt at the first impulse. So we would have to find that there was an initial impulse, there was a fresh impulse, and then there was a resurrection of the initial impulse.
Right, and I would argue it's just one original impulse. Now that I've seen you, I have to do this. The impulse is to penetrate her. It stays the same. And so to answer your question, and I was thinking about that, we don't know when that conversation took place. And the state hasn't shown us that he discussed this after he couldn't penetrate her with his penis and said, "Okay, now I will penetrate you with my finger."
How do you differentiate that from Sellers, the one where the barking dog?
Right. Well, Sellers, we have an intervening event, which is the barking dog.
We have an intervening conversation here.
What?
We have an intervening conversation here.
See, that's the thing. We don't know if that conversation was intervening.
Is there any evidence that the conversation was accompanied with a cessation of touching? In other words, Sellers, we had got off the bed, went out and looked for the dog, or quieted the dog, and came back. So we obviously had a break in the physical action. Here, during that conversation, do we know from the record whether that was concurrent with activities within any body part, or whether there was a break in the action while they had the conversation?
Right. We don't know, and that's my answer to Justice Biles. We don't know. Her testimony is very short. The prosecutor and the defense attorney are being very polite to the victim, given her age. And so I think they tiptoed around a lot of the facts that that this court is asking and that I thought of in preparing. So we don't know, did they actually have a separate conversation? And I wouldn't even know if it was a conversation as in when was the last time you've had sex? It could have been just that one question. Well, not since I've slept with my husband. So it could have been just a one question, one answer. And Sellers, as Justice Johnson explains, he gets up and actually leaves the room and then come back and has that second impulse again to touch the young girl. So that really goes to the meat of our first question.
Well, where do you put KSA 213107?
Isn't that interesting? I would put it under, in my brief, I put it under, do the convictions arise from the same offense? I use that, I supplemented that question by saying, I put it right next to the same elements test.
Well.
And I don't know if it's a separate answer to if the convictions arise from the same offense. You also have, this is the statute, of course, on 213107 is the statute on the statutory defense for when charges arise from the same conduct. And so I kind of put it right after the same elements.
Well, you've got a little contradiction, don't you? The statute, we have a statutory prohibition against conviction for both a crime and an attempt to commit that crime. But if we utilize Schoonover and talk about same elements, then obviously 3301's definition of attempt would create different elements from rape and attempted rape.
Actually, in my brief, I explain that for the same elements test to fail, elements of rape would have to be different from the elements of attempted rape. All the elements of rape fit into, and this is why it's a lesser.
But that I understand the argument, but you're backwards. Attempted rape is a lesser included offense
yes.
of rape by definition, if no other reasons, and then you want to take the lesser included and flip it and say that all the elements of the greater are included in the lesser. Isn't that what you're arguing?
I think I'm being greedy, and I'm trying to argue both ways. Because Schoonover and maybe I should choose one, and maybe that's the point of your question is which one are you going to choose? It's just a lesser, so isn't that your defense? In Schoonover, they said that's a statutory defense. So maybe I should have just done that in my analysis and not gone through the same elements.
Alternatives, possibly. To
yes,
your
alternatives
end.
to why, and that's why I put it after. And that was interesting, Justice Johnson. In preparing for this argument, I was like, well, where do I put 213107? And so I'm basically trying to cover all bases. We would argue that his convictions are multiplicitous. They are under the same conduct. These, by statutory definition, there are two offenses, not just one. We have that on 213107, and I've also applied the same elements test. This was even evident to the defendant in one of his early pretrial motions. He said, I'm charged for 2 crimes. At sentencing, both the prosecutor and the defense attorney described this as one incident. And so we would argue with all that, that these 2 convictions are multiplicitous. I'd like to then get to I have enough time to get to issue 2. Issue 2 is his life sentences. Mr. Weber was sentenced to 2 life sentences for aggravated habitual offender. The state, he had 2 prior Michigan crimes, one an adjudication, the other a conviction. We argued that Mr. Weber can raise this for the first time on appeal. It is an illegal sentence. He did not stipulate to that. I went through in my reply brief how he did not stipulate, and then a 609 letter, which this court received, State v. Donaldson, which says a defendant cannot stipulate to an illegal sentence. With that, we have the Michigan adjudication, which does not fit under a sexually violent crime. Sexually violent crimes in Kansas are basically 3 groups. You have either rape, which is penetration, criminal sodomy, or crimes involving young children. He is convicted, however, of assault with intent to commit criminal sexual assault in the 2nd degree. I've gone through a Michigan case law to show how there's not actually, under the assault statute, you don't even actually have to touch the victim. It's a very broad statute, and we would argue that it doesn't fit under what is a sexually violent crime.
But the assault has to be with a sexual purpose. You don't have to touch, but the assault has to be committed with a sexual purpose under Michigan.
It has to be sexual arousal or sexual gratification.
Well, I think
But it does say purpose, yes.
Yeah, assault with a sexual purpose. So how do we get around the catch-all phrase?
The catch-all phrase being sexual purpose?
On sexually violent crimes, that if it's committed for sexual gratification, because an element of the Michigan offense is if he pleads guilty, then he's pled to having assaulted with a sexual purpose. That's part of the plea for the assault.
So you're saying that.
I'm not saying. I'm asking.
I know. I mean
that the statute we're dealing with has a catch-all phrase, right?
The catch-all for sexually violent.
Yes. My answer to that, and I did not address that in my brief, that is has to be a factual finding by the district court. Whether, and there's case law on this, whether a crime is sexually motivated, the district court needs to make a factual finding. This district court never even used the words aggravated habitual offender at sentencing. So that's my answer to you is this court never makes those factual findings. Certainly, if this court were to remand, it could have the district court instruct the district court to make that finding. There are other reasons why this does not fall under aggravated habitual offender, given that
And so
it's an adjudication.
The district court has to verbalize the finding, even though that finding is inherent in the plea in Michigan. If a plea of guilty in Michigan by necessity included the element that it was committed for a sexual purpose, then the district court has to verbalize that, yeah, he's pled guilty to that and he's admitted that in Michigan.
I would say the district court has to make a factual finding, and there's an Apprendi issue, reaching up right here, that the district court has to make.
Well, there's not an Apprendi issue if the prior conviction included as an element what we have here. We're not making a factual finding in Kansas. That factual finding was made in Michigan. When they accepted the guilty plea, they accepted that he committed that crime in Michigan for a sexual purpose.
I would argue that the district court has to make a finding because it has to say that it's sexually motivated. Sexually motivated sexual purpose, yes.
They're different?
I haven't looked into that, but I've given you case law about a sexual arousal and sexual gratification are quite different from the sexual desires of the offender or another. And so I would certainly want to look into whether the sexual purpose is quite different from sexually motivated. Because is it sexually motivated for the defendant or the other? That might be the key. Or the other could be the victim. And so so while he may have pled to the sexual purpose for himself, I would have to take a look at Kansas law to say, is it sexually motivated for the defendant or another? Or another could be critical, because as this court has held, that makes it that is a distinction.
Any further questions of counsel? Thank you, counsel.
Thank you.
May it please the Court, Assistant District Attorney Matt Maloney for the state. I'll also submit the final 3 issues on the brief. I would note that I think that case law, both recent and more distant on a couple of the issues, conclusively resolved those issues. So I will also focus on the first 2 issues, starting with issue 1. And I realize, as I acknowledge in my brief, that this court has shown on previous occasions a willingness to address multiplicity claims for the first time on appeal. Even before counsel's argument today, I was going to make the argument which I'm now making, which is that I think that this court should revisit that. But I think that the way that this argument proceeded today really illustrates my point. There was a lot of discussion with counsel about the record not being clear, and there were factual questions that were left unanswered. I would argue that that is precisely why an issue such as this should not be addressed for the first time on appeal, because while the ultimate legal conclusion is a legal matter, whether the convictions are multiplicitous, there is no possible way for any court to come to a conclusion without an extensive review of the facts. And I would argue that this should be treated no differently than any other evidentiary issue, whether it's an objection.
What about on the basis of the statutory prohibition?
Statutory prohibition against multiplicity.
That you can't be convicted of rape and attempted rape.
Well, I think that would... I guess I could respond to that by saying that there are also statutory prohibitions against hearsay evidence coming in, and yet we're not going to allow evidentiary issues based on that to be raised on appeal for the first time if the evidence was not objected to at trial.
How is a double jeopardy based claim an evidentiary claim?
Well, I guess my response to that would be, how could this court address this without looking extensively at the evidence? This is at the very least, it's a mixed question of law and fact. As I conceded, the ultimate determination is a legal one. But the only way that decision could be made is with a very extensive review of the facts. And we see in this case, this is the perfect illustration. The defendant is attempting, in essence, to use the fact that it wasn't raised below, and therefore there's not a clear record on it, is trying to use that to his benefit. And I think that's clearly inappropriate. Had this issue been raised at trial as a multiplicity claim, and had the defense made this argument, surely the prosecutor would have been able, or the witness would have been able to testify in more detail, and we wouldn't be questioning what exactly was the conversation. Was it a one question, one answer type situation? Was it a longer dialogue? How long did it last? Was it 5 seconds? Was it 15 minutes?
Was there any factual dispute as to whether there was a break in physical contact?
I think that's another question that's left somewhat ambiguous, uncertain based on the record. I read through my notes during counsel's argument. I didn't see one way or the other any indication of whether there was still physical contact during that discussion or not.
We do know that there was a return. It's clear from the record that there was a return to accomplish the initial impulse.
Yes, after the digital penetration, he did again attempt to penetrate with his penis. That does seem to be clear.
But is that a new intent to rape, or is it the old intent to rape and just getting back to it?
Well, I guess in some degree, in some sense, the answer to that is, for the state's purposes, that it wouldn't matter, because you would still have, we just need to show that there were two separate impulses here, that there was the intent to penetrate with his penis, which he was unsuccessful with, and that there was a fresh impulse to then digitally penetrate.
Then that would be 6455 evidence, wouldn't it? Because you would have two rapes if that was a fresh, if you did the penal rape, digital rape, and then a fresh impulse, then you'd have two rapes and an attempt, and if you're not going to charge that second rape, shouldn't you have given a limited instruction?
Well, I can only respond to arguments that are made on appeal, and that's clearly not one. And in fact, when you read the original defendant's brief, he didn't even raise the argument that the second attempt was creating a problem. In fact, in the defendant's original brief, it's very clear that his argument is that the attempted rape was based on the attempt before the digital.
What was the state's theory of prosecution?
Pardon me?
What was the state's theory of prosecution? How was the jury directed to deal with this issue?
There was a multiple acts, a unanimity instruction given. So the state, obviously, there was evidence presented with respect to both attempts. There was a unanimity instruction given.
The state didn't elect one or the other?
No, I think the state, my recollection is that in closing, the state essentially pointed to the unanimity instruction and said, jury, you have to unanimously agree on this.
I don't want to encroach on the state's discretion on how they charge and prosecute a case, and again, with some sensitivity to the facts here, I'm trying to get to what occurred in what you call the first attempt with the penile penetration. I'm assuming that, reading the facts here, that there was some attempt to penetrate. And what I'm curious of, was there even an attempt? I mean, rape is any penetration, however slight.
Right.
Why isn't that? Why do we even have an attempt?
Apparently, from the facts, it's because there was not even slight penetration. The indication, and I think the dialogue explains it as best it could, is that he was completely unsuccessful to penetrate her at all when he was attempting to do so with the penis, and that was why.
However slight. Okay, so that was not okay.
Yeah, and that was why. And I think, and now turning, and obviously I've made clear my position that I don't think this issue should be reached. But now turning to the merits.
And let me just stop and make sure I understand that you're making a division between step 1 and step 2 in terms of when you're saying there's a mixed question. You would say step 1 in determining whether it's the same act or occurrence is a factual question, and then the step 2 analysis is a legal question?
I think that's correct. I think, yeah, the second part of the Schoonover test, clearly just looking at the elements of the statutes, would certainly seem to be just strictly a legal question. But the first prong, whether the conduct is unitary, is so fact sensitive that that's what I'm arguing.
And doesn't your success rise or fall in this case on the first step?
I'm comfortable acknowledging that that's probably the case. Yeah, I think that if this court were to find that this was truly one unitary act, I think it would be quite difficult for the state to prevail based on the second prong. I don't think that these are, as Justice Johnson indicated, I don't think that under the Schoonover elements test, I don't think that these have identical elements. I think each crime certainly has an element that the other doesn't. But if you were to find that this was one unitary act, then I think that the case law would indicate that you can't be convicted of both the completed crime and an attempt. Now, as to the first prong of that Schoonover test, clearly these were in the same location. Now, Your Honor brought up an interesting question about the time aspect of it, because I think that there was some indication from the victim that this ordeal as a whole lasted 25 to 30 minutes. Now, as I indicated, the record itself only specifies that there was the one question and answer, that the defendant asked how long it had been since she had last had sex. She told him that she had not had sex since her husband had passed away. Obviously, that exchange right now just lasted 10 seconds. But I think we can all agree that there are times when testimony is not going to be verbatim recitation, so it is a little bit unclear. Even if we were to assume most favorably to the defendant, which I don't know that we should, but even if you were to assume that this was just a 5 or 10 second discussion, I think the case law shows that even if we were to say this was at the same time, that there was not a big enough time gap to say that the time element of the Schoonover test was met from the state's perspective, that doesn't mean that there was not a fresh impulse or an intervening act. And Sellers, these cases are so fact sensitive that each side can always cite cases that purportedly support their position. Sellers is the case that I rely on most heavily because I think that factually it is the most similar to this case, and I recognize that unlike in Sellers, we don't have the defendant leaving and then coming back to the bedroom.
And subsequent to Sellers, we determined that body part isn't really relevant on an alternative means, that the gravamen of this offense is penetration.
Right.
So that makes the break in the action more important in my mind, because you can't rely on a change in body part like the state used to.
Which is why I did not cite Zamora in my brief, because even though Zamora, as far as the facts of that case, are virtually identical to this situation here, but in ruling in the state's favor in Zamora, the court did rely on the fact that one act involved the penis and one was digital. And that was why I didn't cite that case, because frankly I don't think, in light of the recent alternative means cases, that analysis helps the state at all in this case. So here I am arguing that the statement, the question that he asked and her response, that did create a fresh impulse and an intervening act. Just like in Sellers, it's important to note that even though this court found that from a time and location standpoint, they were the same. The court said that the 30 to 90 second break was not enough to be to show that it was at a different time. And yet, despite that, this court ruled that that it wasn't multiplicitous, because what happened during that short period of time was enough time for the defendant, quote, to reconsider his felonious course of conduct. My argument is that the question and answer in this case likewise gave the defendant an opportunity to reconsider his course of conduct, and he made a fresh decision to commit a second act. Clearly, if he, after the point that he had failed to penetrate the victim with his penis, and he asked her how long it had been since she had had sex, and she told him that it had been since her husband died, at that point, he had an option. And if he had stopped and not made any further act, we would not have been able to charge him with rape because there was no penetration when he attempted to penetrate with the penis. So he had an opportunity right there to reconsider his course of action. He chose, instead of stopping, he chose to commit a second separate act. And you can, even though the record is somewhat undeveloped on this issue because it wasn't raised, I think we can all reasonably infer what happened here, his thought process. She told him that she hadn't had sex in essentially a decade, and he realized that his first course of action probably was not going to be successful because of that. And so he chose a different approach, a different course of conduct, and that was what he chose to do. And I think that just like the defendant in Sellers going to check on the dog and essentially making sure that the coast was clear, in this situation he had enough time to reconsider, and the fact that he did change his course of conduct shows that he made a conscious decision. We don't have to speculate with respect to whether that statement from the victim was enough to give him an opportunity to reconsider.
Fresh impulse is akin to premeditation. You can have a fresh impulse during the commission of the act?
I would argue yes. I think this case is a very good example of that. And I think that
before you run out of time, I think we understand your argument in that regard. I want to get you to the second issue on the habitual sex offender. The crime that was pled to in Michigan did not require touching.
Right.
This criminal sexual conduct that it speaks to that's assault with intent to commit criminal sexual conduct. That required a touching, but the assault with intent did not require touching. So how do we get to comparable to aggravated sexual battery, or how do we get there?
Well, I think a couple things. One is that, as Your Honors indicated, there is in our statute, our Kansas statute that was applied here, there is the catch-all provision about whether it's
and we could make that factual finding. I mean, I think we could probably do it if we worked real hard here, based on the elements, going back and us digging out the elements of the Michigan and saying that, well, sexual purpose may be the same. But is that for us to do?
Well, I don't think you'd have, as Your Honor indicated, I don't think you'd have to work that hard, because he pled to a crime that, while touching itself was not an element of, the assault with the sexual purpose is an element of that crime.
And did the district court find that? Is that what the...
Well, and that was the second part of my answer here, is that, again, like the first issue, to the extent that the record is underdeveloped and that this court would feel like it has to make factual findings, I would argue, perhaps even more strongly on this issue, that that's the defendant's responsibility based on the way that this issue was handled below. This is not just a situation where the defendant acknowledged that he had these prior convictions from Michigan, and there was no discussion about the effect of those.
Well, I understand your argument is that defense counsel says, yeah, that would apply. But defense counsel can't stipulate to the law. And you and the defense counsel can't stipulate that this defendant's a habitual sexual violator.
Right, but this defendant was in the courtroom, and he heard, and that's why I think it's important.
It doesn't matter.
It does when there's an extensive discussion about the effect of the convictions.
Why? The court has to make the legal rulings. The parties do not get to stipulate as to the legal effect of the facts. And they could have talked all day and said, yeah, we agree, this is what it is, but the court has to make the legal ruling that, based on these facts, here's what applies. And where do we have the court making the appropriate legal rulings to apply the habitual violator?
I don't know that the court used any magic words and said, I hereby declare that the defendant was the crime was sexually motivated. What we do have is the defense attorney telling the judge, you have to impose a life sentence because he has these crimes that meet the criteria. We have the defendant sitting by silently, and the prosecutor specifying that it was the Michigan crimes that formed the basis for the...
What if those crimes, let's say we have that scenario, and what if those crimes don't form the basis of a sexually violent offense pursuant to the habitual sexual violator statute? What if we have that? You can't undo it at that point? Is that what you're saying?
Well, I don't want to say something that would seem too extreme, but at some level,
we're talking about doubling or tripling the sentence here, depending on which prior we're talking about, or how many priors we're talking about.
I do think at some level, the invited error doctrine does have to have meaning, and I found, as I was preparing for the argument, I found...
So if he's convicted of misdemeanor theft in Michigan, and the counsel stipulates, yeah, that's a sexually violent offense, and they don't look any further, that would be good enough? He stipulated to that?
Well, clearly it wouldn't be binding on the district court, but I think that the invited error doctrine indicates that it's not so much whether it's binding on the district court, but it's whether a defendant is essentially foreclosed from challenging him when it's his or her own conduct that has invited and led to the error.
I'm wondering if has the legislature restricted when that finding can be made? I'm looking at the definition in 214642C3M of sexually violent crime. And it says it includes any act which at the time of sentencing for the offense has been determined beyond a reasonable doubt to have been sexually motivated. Does that mean back to the first offense?
I interpret that to mean at the time of sentencing for the crime that he's being sentenced for here in Kansas, would be my interpretation of that. I had a little uncertainty about that myself when I read it the first time, but I ultimately determined, perhaps wrongly, perhaps not, that it was referring to at the time of the sentencing for the current conviction, that the determination has been made that the prior convictions were sexually motivated.
And does that then bar the state, if they haven't met that burden of proof before sentencing, to use that offense under that catch-all provision?
If I'm understanding your question, I would think yes. I mean, if the state comes to sentencing, and at the time of the sentencing in this current case, if we had not presented, if there had been nothing to go off of to show that the crime was, but I think, and that's again why I think that the manner in which this played out is so important. We can't forget that the defendant did file a generic challenge to these two Michigan convictions. He didn't specify a basis. He wasn't even clear whether he was challenging their existence or their legal effect. And then at sentencing, essentially before anything even had an opportunity to happen, counsel stood up and said that the court should deny that challenge based on the documents that the state provided. So the state did provide, I know we at least provided journal entries of the Michigan convictions. There might have been further documentation than that.
So we would have to go, based upon the burden of production of the state at this time of sentencing, our decision would have to be based on the elements provisions?
Well, I think that the state met its burden at the time of sentencing by producing the documentation that satisfied that. As I recall, these criminal history type challenges, it's the PSI itself is enough unless the defendant challenges, and then if the defendant challenges, we have a burden to provide additional documentation. And in this case, we did that, and that documentation was sufficient for the defendant's purposes, and then he agreed that prior conviction did fit what was necessary. I would simply argue, as with the first issue, I don't think you should reach the merits. If you do, I think that the evidence is in the state's favor. Worst case scenario for the state, I would ask that this simply be remanded for a rehearing. I think in her brief, the defense is asking, almost implying that this should just be reversed and that the sentence should be vacated and they should get rid of the life sentence. Based on the way this transpired, I would think that at best the defendant could hope for would be remand for a new hearing in which the state could present, if necessary, additional evidence, and so that the court could say whatever it needs to say in order to satisfy. But I clearly don't think that it would be appropriate to simply reverse the sentence with based on the record before it.
Any further questions of counsel?
Real quick one. You would agree that the instruction here on attempted rape allowed the jury to convict based on any overt act, but that the complaint specified an overt act?
Factually, I would agree, and my response simply would be that that makes no difference.
Well, okay.
Right, right.
You're arguing it's harmless because of the way it was argued to the jury, basically?
No, not even that now. I would argue that in light of the recent alternative means arguments, opinions, Britt and Sandler, that were both decided since this case was briefed, and those were the cases in which the court held that penis, finger, and any object are not alternative means.
But here we're talking about an overt act, and the overt act could be that he locked the front door en route to go accomplish the rape, or the overt act is not have anything to do with body parts. In fact, your claimed overt act is that he climbed on top of her or whatever, and there could be any number of overt acts alleged, and we've all seen them. And what I'm getting at is if you have a complaint that specifies an overt act or overt acts, but then you give the generic jury instruction that you just have to find an overt act, why isn't that a broader instruction than was charged?
Two things. First, I will say that with respect to your initial question, I would rely, if it's necessary to get there, I would rely on harmless error in the sense that we clearly did elect, which means, and not only did we elect, but there was no evidence presented with respect to any other theory, unlike the case that the defense relies on in Trautlov. I don't know if I'm pronouncing that right, but in that case there was evidence with respect to other theories, and in this case there was not. But So if necessary, I would rely on harmless error. But I would also note that in the brief, as argued by the defense was not making the argument that Your Honor just pointed out, which would be that there could be that the overt act could even be another non-sexual act. They were simply arguing that the instruction was too broad because it included finger, penis, and any object. And that was why my initial response was to indicate that I believe that Britt and Swindler themselves would be sufficient to answer this question, because we now know that those three things are simply options within means.
Any further questions of counsel? Anything you've failed to say yet, counsel?
I'm sure I'll think of it on the drive back to Wichita, but for now I would just respectfully request that the defendant's convictions and sentence be affirmed.
Very well, thank you. You reserve 2 minutes for rebuttal.
I'm going to start with issue 2 and then we'll move back to issue 1. First, issue 2. This court asked a lot of questions to the state about this Michigan conviction, but if you read the state's brief, it never even addresses the merits of that issue. Take a look at it. I've read it twice, I've read it 3 times. I can't find out where the state is addressing. So for the state to ask here, I had oral argument for you to remand so the district court can make the necessary factual findings is something that was not brought up in its brief, was not something that I could address in my reply brief. So we argue that the state basically, his only argument is he did not stipulate. And as this court has pointed out, a defendant cannot stipulate to an illegal sentence. To get to the point that Justice Lukert mentioned, and I know there is case law on it because I've won on this case. I know there's a Johnson County case, I think it's State v. Allen, where the district court failed to make a finding that the offense was sexually motivated. But here, an act which at the time of sentencing for the offense has been determined beyond a reasonable doubt. Okay, so we have to make a reasonable doubt finding, and that's by the the district court, that's how they've had it set up right now, to have been sexually motivated. And sexually motivated means one of the purposes for which the defendant committed was for the purpose of the defendant's sexual gratification, not the defendant or another. So we would argue...
How does the trial judge know to make that finding if the defendant says, I have this Michigan conviction and it qualifies as a sexually violent crime under Kansas law?
Well, what you're describing is a case that isn't before us today, because that is not what took place at the sentencing. Like I said before, the district court never even made a factual finding.
The defense counsel says deny our motion challenging because he's the correct sentence is life without parole.
This is what he says. This court could not depart at this stage, even if the court wanted to. So no reason then for me to go through. We're filing this. We expect the court to overrule us, and then we could appeal. Oh, okay. Here it is. But I think the main thing, and the court is already aware of this, that the court has to impose a life sentence. I don't know if that's enough to say he's stipulating that is an aggravated habitual offender. And what's important here is the state is arguing, well, he never objected to the criminal history. And as this court has said in LaBelle and other cases, there's a big difference between stipulating to criminal history and stipulating to the classification. And classification is made by the district court at sentencing. A more thorough record would have helped here. And if the judge had made that ruling, we would argue that there needs to be more here before you can waive away. But even if we say he stipulated, that's the whole point of the 609 letter, is to say, as this court has said, the defendant cannot stipulate to an illegal sentence. I don't believe it is the defendant's burden. There needed to be more here at sentencing before you start pushing the burden on the defendant. And yes, we do expect the district court to say those magic words, to make something.
Counsel, before you go on, you're out of time.
I see
Would
that.
you like about 15 seconds to conclude?
Yes. This court reject the state's argument that the first part of Schoonover is a factual finding. We already went through that with all the Jessica Law cases. This court has never made that finding. For it to now remand it is creating new law in terms of something that it's never done before. It's always said that this is a legal question. It is the state's burden. I think I'm probably going over 15 seconds. But I'm going to end with Justice Johnson's dissent in Sellers, which is the two may go to the state and the two may go to the defendant, but the state does not win the toss-ups. And here we have same location and same time, and so we would argue that those two at least work in our favor. Thank you.
Thank you, counsel. Thank you both for your arguments this morning. The court will take this matter under advisement. This time the court is in recess for 15 minutes.